In this lesson, we're continuing our discussion of subject matter jurisdiction. Specifically, we're going to focus in on removal. But first, remember, think back to our basic requirements at a really broad, high level. Remember, here we say to hear and decide a case before it, a court generally must have three things. Number one, court needs subject matter jurisdiction of the particular type of case before it. Number two, court needs personal jurisdiction of the defendant. And number three, we know that court needs proper venue based on locality. Of course, in this lesson, we're continuing our discussion of this first basic requirement, which is subject matter jurisdiction. And remember, we're really thinking about subject matter jurisdiction at the federal level, whether this is the type of case that this federal court can hear and decide. And remember, here we say, other than subject matters exclusively allocated to federal courts by law, there are generally four main ways for a federal court to obtain subject matter jurisdiction over a case. And thus far in our series on civil procedure, we've discussed federal question jurisdiction, diversity jurisdiction, and supplemental jurisdiction. Of course, in this lesson, we're moving on to removal. Okay, and the good news here with removal is if we understand federal question jurisdiction and diversity jurisdiction, specifically those two concepts, removal should be a breeze. It's basically a reapplication of the same analyses. We'll see there's a couple nuances thrown in there, but really, for the most part, if we understand federal question and diversity, removal is just reapplying these concepts. So it should be pretty straightforward. Would highly recommend, if you haven't seen our lessons on federal question and diversity, stopping here, go back, watch those, and then you'll be ready for removal. If you haven't seen those, if you don't have federal question jurisdiction and diversity jurisdiction kind of down, removal might not make any sense. So we want to make sure we have those concepts down before we get into removal. Okay, but what is removal at a really broad, just kind of high level? So we know in civil procedure that the plaintiff gets to choose where to file an action, right? The plaintiff essentially selects the forum. And the plaintiff can take their complaint and they can file that complaint in any court they want. They can go to any state court, any federal court. The plaintiff gets to choose where to file their action, right? It's kind of a bedrock principle of American jurisprudence. So the unique feature about removal is it's kind of one of these rare instances where the defendant actually gets some say in the forum selection process. We'll see if certain requirements are met. A defendant, not a plaintiff, a defendant can actually take an action that was filed in state court and move that action to federal court, essentially changing the forum. Okay, so remember, plaintiff gets to choose where to file the action. This is a bedrock principle, but if certain requirements are met and that plaintiff chose a state court, defendant can come along and potentially remove the action to federal court. And there's a lot of reasons a defendant might want to do this. The most common would just be that the defendant perceives the federal court is going to be more favorable, or at least more neutral. We know that there's perceptions out there about different states and the different state laws in different states. And so if you're an out-of-state defendant being hailed into some, court you're unfamiliar with, you might think that the federal court in that circumstance is going to be more favorable or a more neutral forum to litigate your case. For instance, if you have a California plaintiff hailing you from Texas to California into a California state court, we know a defendant from Texas might think, hey, this California's court isn't going to give me a fair shake. I want to take this to what I think is going to be a more neutral forum, federal court. And if certain requirements are met, that defendant from Texas may be able to do that, may be able to take the action that was filed by a California citizen in California state court and remove it to federal court in an attempt to get a more favorable forum, or at least what is perceived as a more neutral forum. Okay, and kind of this policy consideration behind it of an out-of-state defendant being hailed into the plaintiff's home state is something to keep in mind. We'll see this kind of comes up as a theme as we work through some of these requirements for removal. But we can get into more of the basics. So how does a defendant actually go about removing a case from state court to federal court? What are the requirements? Well, we say here, if a case filed in state court could have originally been brought in federal court, usually because the federal court has federal question jurisdiction or diversity jurisdiction, the defendant generally has the option to remove the case from the state court to federal court. And then we get a couple of exceptions here. We have some procedural and timing requirements we need to think about, and we'll see certain actions are not eligible for removal when the sole basis for such removal is Section 1332 diversity jurisdiction. Okay, really important with this kind of second exception here, where certain actions are not eligible for removal. That only applies when we're dealing with, or at least when the sole basis for removal is Section 1332 diversity jurisdiction. So if the basis for removal is federal question jurisdiction, right? If the plaintiff files a claim that arises under federal law, we don't have to worry about this eligibility requirement under number 2 here. Okay, and that's something to keep in mind as we work through some of these practice problems. But as a starting point rule outside of these exceptions, it's very straightforward, right? If a case filed in state court could have originally been brought in federal court, the defendant generally has the option to remove it from the state court to federal court. So if federal question or diversity jurisdiction is satisfied, our starting point rule is, well, then the defendant can remove it from state court to federal court. So let's apply this to a really easy practice problem. We have practice problem 1.0. Let's say here, Pam brings a claim that arises under federal law in state court against Doug. Can Doug remove the case from the state court where it was filed to federal court? Well, the question is, could Pam have originally brought that claim to federal court? And the answer is yes. Assuming all procedural requirements are met, Doug can remove the claim from state court to federal court because the federal court has original jurisdiction over the claim under Section 1331 federal question jurisdiction. Essentially here, Pam chose to bring this claim to state court, but she could have brought it in federal court, right? The federal court has jurisdiction to hear this claim under federal question jurisdiction. Her claim arises under federal law. We know that satisfies Section 1331 federal question jurisdiction. So Pam just so happens to file this in state court, but she could have filed it in federal court. And that's the primary reason that Doug can now remove it from state court to federal court, because it could have originally been brought in federal court. And remember, those big exceptions we're going to think about don't apply here because the sole basis is not diversity jurisdiction. This is based on, the removal here is based on federal question jurisdiction. So a lot of these exceptions we're going to discuss would not apply. So removal as an analysis is really straightforward when the basis for the removal is federal question jurisdiction, when we have a claim that arises under federal law. If the sole basis for the removal is diversity jurisdiction, there are a couple things we have to keep in mind, and we'll get to those as we progress through this lesson. Well, let's just start with some of the basic kind of procedural and timing requirements that apply either way, whether the basis for removal is based on federal question or diversity. These kind of rules, these procedural and timing requirements would apply. Our first one is that only defendants can exercise removal. Only defendants can remove a case from state court to federal court, not plaintiffs. This is very straightforward. There's really no circumstance where you could see a plaintiff who's filed an action in state court use removal to move the case from state court to federal court. This is basically just a bright line rule. We can apply it to a practice problem. Let's see if I can trick anyone with this really bright line rule with practice problem 2.0. Okay, let's say Pam brings a tort claim in state court against Doug. Doug files a counterclaim against Pam that arises under federal law. Can Pam remove the case on the basis that the federal court has federal question jurisdiction over Doug's counterclaim? Well, there's a lot of problems here, but the short answer is no. Remember, Pam is a plaintiff. Only defendants can remove a case from state court to federal court, not plaintiffs. So this whole thing about Doug bringing a counterclaim doesn't matter, right? Pam is the plaintiff. She cannot remove a case from state court to federal court. She filed it in state court. She's the plaintiff. She cannot remove it from state court to federal court based on really anything the defendant is doing. It doesn't matter what Doug is doing. So even though Doug has filed this counterclaim against Pam and it involves federal law, that's not going to allow Pam, the plaintiff, to remove the case. Only defendants can remove a case from state court to federal court. So that's the short answer. But it's also worth pointing out here that under the well-pleaded complaint rule, the federal court cannot exercise federal question jurisdiction over Doug's counterclaim to begin with. Right here, the federal court does not have original jurisdiction over this claim. Unless diversity was satisfied, and we have no facts here on the citizenship of the parties or the amount in controversy. So we don't know if diversity is satisfied. But assuming diversity jurisdiction is not satisfied, well, the federal court here does not have original jurisdiction over this claim. Remember, this is Louisville and Nashville Railroad v. Motley, the well-pleaded complaint rule. Whatever the defendant is doing is irrelevant in our federal question analysis. Remember that whole thing I said about putting the blinders on and only looking inside the four corners of the plaintiff's complaint? Remember here, Pam brings a tort claim in state court against Doug. So Pam is bringing a state law tort claim in state court. The federal court does not have federal question jurisdiction over a state law tort claim. Doesn't matter that Doug's bringing this counterclaim. Under the well-pleaded complaint rule, we only look at the claims being brought on the face of the plaintiff's complaint when we're trying to decide whether federal question jurisdiction is satisfied. So for several reasons, the answer here is no. Pam cannot remove the case on the basis that the federal court has federal question jurisdiction over Doug's counterclaim. Number one, Pam is a plaintiff. Plaintiffs cannot remove cases. Only defendants can exercise removal. Number two, the federal court does not have federal question jurisdiction over Doug's counterclaim. That's the well-pleaded complaint rule in Louisville and Nashville Railroad v. Motley. Okay, so next kind of procedural rule to think about here is consent when there are multiple defendants. Generally, if there are multiple defendants to the action, all of the defendants who have been properly joined and served must join in or consent to the removal of the action. Again, this is a really kind of bright line, straightforward rule. If you have a plaintiff suing two defendants, and one of the defendants exercises removal, if the other defendant does not join in or consent to that removal, then the case will not be removed. Basically, all of the defendants have to consent or join in, or the case cannot be removed. Really straightforward. There is an exception to keep in mind here when defendants are separate parties to federal and state law claims joined in the action. Again, we haven't gone into a lot of detail on joinder rules, and I'm not going to get into that here, but we do understand in civil procedure, at least we can accept that claims can be joined in one action. Basically, you can have multiple claims joined under the rules of federal rules of civil procedure in one lawsuit. And if you have a claim against a defendant and another defendant, and one of the claims is a state law claim. Basically, against one defendant, you have a state law claim, and against the other defendant, you have that federal law claim. Well, if the defendant who wants to remove the case from state court to federal court, once that case goes to the federal court can sever the lawsuit that's been joined. So you have two claims that have been joined. You have a state law claim and a federal law claim that have been joined. It gets removed from the state court to the federal court. The federal court can sever the action back into two claims, hold on to that federal law claim, and basically remand the state law claim back to state court. So it's kind of this unique exception where all of the parties would not necessarily have to consent to have it removed. Basically, just the federal law defendant, whoever that one is, right? The defendant who's on the defendant to the federal law claim would be the only one that really has to consent there, because the federal court can sever the action and remand the state law claim and the defendant to the state law claim back to state court and basically keep that federal law claim in federal court. Okay, and that's kind of just severing multiple claims that have been joined in an action when defendants are separate parties to federal and state law claims. Okay, but other than that, which is kind of a unique exception, we say if there are multiple defendants to the action, all of the defendants who have been properly joined and served must join in or consent to the removal of the action. Okay, next up, we kind of get this 30-day procedural requirement. We're thinking about these procedural rules. There is a 30-day window on removal. So here we say the defendant must file a notice of removal within 30 days after the receipt of a copy of the initial pleading setting forth the claim for relief upon which such action or proceeding is based, or within 30 days after the service of summons upon the defendant if such initial pleading has been filed in court and is not required to be served on the defendant, whichever period is shorter. It's a lot of words. The basic idea here is when we see this tested in law school and on the bar exam, once the defendant is served, you're going to get this fact somewhere in your fact pattern. The defendant gets served, right? He's got 30 days to file. He gets like a 30-day window triggers, and he's got 30 days to file a notice of removal. Once that 30-day window passes, basically the expiration of removal hits. The defendant can no longer exercise removal after that 30-day window passes. So again, defendant gets served. Just think he's got 30 days to file that notice of removal. Use it or lose it. If he doesn't file the notice of removal within 30 days, he loses the option to exercise removal. Important note here is that mere receipt of the complaint without any formal service of process does not trigger the 30-day window for removal. We get a really seminal case here, Murphy Brothers Incorporated v. Machete Pipe Stringing. In this case, Machete sued Murphy in Alabama state court. A courtesy copy of the complaint was faxed to Murphy, but the official service by certified mail came later. Murphy removed the case to federal court 44 days after receiving the fax copy, but within 30 days of official service. Was removal timely? Here, the Supreme Court of the United States says yes. Basically, that courtesy copy without formal service doesn't trigger anything. It doesn't trigger the 30-day window. So basically, the fax is sent, 2 weeks passes, 14 days passes, and then the defendant is served. At that moment in time, when the defendant is served, that's when the 30-day window starts. And in this case, the defendant did file within the 30-day window from the moment in time that he was served. Therefore, Supreme Court says removal was timely. Okay, just something to keep in mind. If you see like a courtesy copy of the complaint getting sent to the defendant, that does not trigger the 30-day window. We need that official service of process. Okay. Another thing to keep in mind here with the 30-day procedural requirement is if there are multiple defendants involved, we can get some interesting situations. If multiple defendants to an action are served at different times, a later served defendant can initiate removal and the earlier served defendants can still consent and join in, even if their own 30-day period to initiate removal has expired. Okay, so we kind of have a little fact pattern drawn up here at the bottom. Imagine that our first defendant is served and 40 days passes. So our defendant is served and 40 days passes. Well, we know after day 30, defendant 1 can no longer remove the action. His 30-day window has passed. But let's say 40 days later, a second defendant is served, right? Well, at this point, that second defendant now gets 30 days to file for removal. Okay, and let's say 20 days passes and defendant 2 initiates, right? So within the 30-day window, our second defendant has now filed his notice of removal. Well, at that point, even though our first defendant's 30-day window has expired, he can still consent and join in. Okay, this is just something to keep in mind if we have multiple defendants. Those earlier served defendants can consent and join in even if their 30-day window has passed. Okay, just something to keep in mind with the 30-day requirement if we have multiple defendants. Okay, another nuance is what happens when a case kind of starts as non-removable and then at some point later it becomes removable. How does this work with the 30-day requirement? And there's a lot of ways, right? A case can start as a non-removable case and become removable. Obviously, the big two would be when the court does not have federal question jurisdiction to start, but the plaintiff basically amends their complaint in such a way where now the court does have federal question jurisdiction, or the same with diversity jurisdiction, right? The original complaint as filed, court does not have diversity jurisdiction, but then there's some amendment. Usually it would be like a non-diverse party is dropped from the lawsuit, and now the court would have diversity jurisdiction. So in these cases, how does that play with the 30-day procedural requirement where you could have a situation where the lawsuit starts as non-removable, but later on it's ascertainable that this is now removable? Well, in these cases, if a case is not removable based on the initial pleading, a notice of removal may be filed within 30 days after receipt by the defendant, through service or otherwise, of a copy of an amended pleading, motion, order, or other paper from which it may first be ascertained that the case is one which is or has become removable. So we have another little hypo here at the bottom. Imagine that our defendant is served and the case is not removable, right? Again, this could be anything. Say you have a defendant who is served on we could do diversity jurisdiction. So let's say that we have a plaintiff from Texas suing a defendant from Texas. So there's no diversity. But we have a second defendant who's from New York. So 40 days passes, right? The case is not removable. Say it's a state law claim, so there's no federal question jurisdiction, and we don't have diversity between the parties. We have a plaintiff from Texas suing a defendant from Texas and a defendant from New York. Well, let's say after 40 days passes from, that defendant being served, the defendant receives a copy of an amended pleading, right? And in this amended pleading, the non-diverse party from Texas is removed. So his co-defendant from Texas is removed. Now we have a plaintiff from Texas suing a defendant from New York. So complete diversity between the parties is restored. Well, at that moment, right, when the defendant receives a copy of that amended pleading, that's the moment where it was first ascertainable that the case is one in which it has become removable. So when the defendant receives the copy of that amended pleading, the 30-day window starts. So even though it was 40 days had already passed since the defendant was originally served, because the case has been amended and now, or at least because the pleading has been amended and it's now ascertainable that the case is removable, the 30-day window starts from the moment the defendant receives the copy of that amended pleading. If the defendant files his notice of removal within that 30-day window, okay, removal can be timely. Okay, that's the 30-day kind of procedural requirement we need to keep in mind. That would apply whether the grounds for or the basis for removal is federal question or diversity. Now we can get into the situation where removal is based on diversity of citizenship. Certain actions are not eligible for removal when the sole basis for such removal is Section 1332 diversity jurisdiction. Here we're going to have the home court rule and the 1 year limitation. So we can start with the home court rule. This is Section 1441B2. Notably, home court is in quotations because this is what I call the rule, right? This is not something you're going to see courts use. So if you're writing an essay, do not use home court rule. You can refer to this as Section 1441B2. But again, I think this will just make it easier to remember in your head. Okay, so if an action under Section 1441B2, if an action is eligible for removal solely based on diversity jurisdiction, the action cannot be removed from state court to federal court if any of the defendants are a citizen of the state where the action was originally filed. Okay, this should make a lot of intuitive sense. If the action is eligible for removal solely based on diversity jurisdiction, a defendant who is at home in the forum state cannot remove the case from state court to federal court. Okay, and the idea here is really, why would the defendant want to do that? Okay, if you have a California plaintiff suing a New York defendant in New York State court, right? So the plaintiff is the out-of-state party. Why would that defendant who's at home in the forum state and potentially has home court advantage, so to speak, why would that defendant want to remove the case from his home court to federal court? Okay, so if an action is eligible for removal solely based on diversity jurisdiction, the action cannot be removed from state court to federal court if the defendant is essentially at home where the action was originally filed. Okay, so we can just apply this rule to a practice problem to kind of see how it plays out. This is practice problem 3.0. Here we have Pam, a citizen of state A, brings a state law tort claim in a state court of state B against Doug. Of course, Doug is a citizen of state B seeking $100,000 in damages. Can Doug remove the case from the state court of B to federal court? This is what we just talked about. The answer is going to be no. Here, the action is eligible for removal solely based on diversity jurisdiction, and the defendant, Doug, is a citizen of the state where the action was originally filed. Doug is at home in state B. Therefore, Doug cannot remove the case. It should be pretty easy to apply once you know it. If the defendant is at home in the forum state and the action is based solely on diversity jurisdiction, okay, then the defendant is not going to be allowed to remove the case from that state court to federal court. That's Section 1441B2, what I call the home court rule. Okay, and here, just as a quick refresher in this fact pattern, remember, Pam is bringing a state law claim. If Pam had brought a federal law claim, right, a claim that arose under federal law, then potentially Doug could remove the case because the action would not be based solely on diversity jurisdiction, or at least the eligibility for removal would not be based solely on diversity jurisdiction. It'd be eligible based on federal question jurisdiction. But because Pam is bringing a state law tort claim, the only eligibility here is diversity jurisdiction. Complete diversity between the parties, amount in controversy exceeds $75,000. Okay, with that, we can get into the 1 year limitation. If an action is eligible for removal solely based on diversity jurisdiction, the action may not be removed more than 1 year after commencement of the action unless the district court, the federal court, finds that the plaintiff has acted in bad faith in order to prevent a defendant from removing the action. Again, this should be a somewhat easy rule to apply once we know it. Basically, once an action is commenced that is eligible for removal solely based on diversity jurisdiction, again, so you're going to have some state law claim where the parties are diverse and the amount in controversy exceeds $75,000. After 1 year, the action is no longer eligible for removal. It's just a hard cap. 1 year passes, it's no longer eligible for removal. So we can apply this to a practice problem. We have practice problem 4.0. Here, Pam, a citizen of state A, brings a state law tort claim, so a claim that's not eligible for federal question jurisdiction. Pam, a citizen of state A, brings a state law tort action in state court against two jointly liable defendants, Doug, a citizen of state A, and Debbie, a citizen of state B. Pam is seeking $100,000 in damages. 14 months after Pam files the state law tort action, Doug is dismissed from the suit, restoring diversity. Without Doug, Debbie recognizes complete diversity is restored between the parties. Consequently, within 30 days of Doug's removal, Debbie files a notice of removal on the basis of diversity jurisdiction. Is the removal timely? Okay, so let's work through this. Here, although Debbie filed the notice of removal within 30 days from when it could first be ascertained that the case became removable, 1 year had already passed since Pam originally filed the state law tort action against Doug and Debbie. Therefore, Debbie would not be permitted to remove the case on the basis of diversity jurisdiction unless Pam had acted in bad faith in order to prevent Debbie from removing the action. Okay, so this is just a bright line application of the 1 year limitation. Action is commenced. 1 year passes, the action is no longer eligible for removal. It does not matter that it took 14 months for it to become ascertainable that the action was removable. This is a hard cap. Once 1 year passes, you cannot remove the case. If eligibility for removal is solely based on diversity jurisdiction, which in this case, we know that's true because the plaintiff brought a state law action. So federal question is not triggered. So because eligibility for removal was based solely on diversity, once that 1 year passes, you cannot seek removal. The defendant cannot seek removal in those cases where the eligibility for removal is solely based on diversity jurisdiction. So even though the 30-day requirement would be satisfied, remember we talked about this, the pleading is amended, the non-diverse party is dropped, it now becomes ascertainable that the case is removable, so defendant files for removal within 30 days, that all works. Problem is, because the eligibility is solely based on diversity jurisdiction, that 1 year limit has passed. That's a hard cutoff, okay? It's no longer eligible for removal. Again, the only exception there would be if Pam had acted in bad faith in order to prevent Debbie from removing the action, but we have no facts that would suggest bad faith. Okay, so that's all of the major rules we need to cover with removal when we're thinking about those procedural and kind of timing requirements and actions that are eligible for removal solely based on diversity jurisdiction, the home court rule, and the 1 year limitation. If we have all of that down, remember, removal is essentially just reapplying the rules of federal question and diversity. The big picture idea is if a plaintiff brings an action in state court that could have originally been brought in federal court, usually because the federal court has federal question or diversity jurisdiction, the defendant generally has the option to remove the case from state court to federal court. We just have to think about those exceptions we went over. Basically, only defendants can remove, not plaintiffs, the 30-day requirement. And then if the action is eligible for removal solely based on diversity jurisdiction, we have those two additional kind of scenarios we have to think about, the home court rule and the 1 year limitation. Otherwise, it's just a reapplication, really, of federal question and diversity. Okay, One final note to make here while we're thinking about removal, and we're going to come back to this when we get to venue. So I don't want to get too much into the rules of venue in this lesson because we're going to have a whole different segment on venue. But it is worth noting when we're determining proper venue for removed cases, we apply a different kind of statutory framework than our typical venue analysis. So here we say proper venue for an action that has been removed under section 1441A is in the federal court for the district and division embracing the place where such action is pending. Upon removal, venue is proper in the federal court of the state where the action in the state court was pending. Okay, this is really important because it means section 1441A dictates proper venue in removal cases as opposed to section 1391, which is the conventional statute used for determining proper venue in non-removal cases. So when we get to venue, right, in future lessons, we're going to do this whole breakdown of how you determine where venue is proper. And we're going to use section 1391, and that applies to all non-removal cases. But if we have a removal situation, venue is proper where 1441A says venue is proper, which is going to be the district and division embracing the place where such action is pending. So venue analysis in removal cases is very easy. It's like a legally ascertainable fact. It's given to you. You don't have to go through the whole 1391 analysis that we're going to talk about in a future lesson. Okay, so this is just something to keep in mind when we're determining proper venue for a case that has been removed from state court to federal court. So let's just apply this to a quick practice problem so we can see this. And again, we haven't discussed venue yet. We're going to get there in future lessons. But the idea here is just understanding when the case is removed from state court to federal court, if we're trying to determine where venue is proper, we apply 1441A, not 1391. So here under practice problem 5.0, we have Pam, who brings a claim that arises under federal law in a state court of state A against Doug. Doug timely seeks removal. Where is venue proper? Okay, so it's a removed case. So we apply the removal rules from 1441A, not section 1391, which we're going to get to in future lessons. So here, venue is proper in the federal court of state A because state A is the district embracing the place where the action in state court was pending. It is irrelevant where venue would be proper under section 1391 because section 1441A governs venue in removal cases. So again, this is very easy. Pam brought her claim that arose under federal law in a state court of state A. So that's where the action is pending. The action is pending in state A. So because state A is the district embracing the place where the action in state court was pending, that's where venue is proper. Doesn't matter if 1391 says actually venue would be proper over in this other. Doesn't matter. I don't even want to get into that. We don't even look at 1391 when we're dealing with a case that has been removed from state court to federal court. Okay. And again, it's going to be given to you. You're going to know where the state is, where the action was pending. It's going to be given to you in the facts. That is where venue is proper. Okay, so that's the last note we need to make on removal. So from here, we've wrapped up the four major ways where a federal court can obtain subject matter jurisdiction. We've talked about federal question, diversity, supplemental jurisdiction, and now we've talked about removal. Those are the four main ways that we know a federal court is going to obtain federal subject matter jurisdiction. So with that, I think we're going to be finally ready to move on from subject matter jurisdiction to personal jurisdiction. So I'm really excited to get into personal jurisdiction. But with that, I do wish you all the absolute best. And until then, I'll see you at our next lesson.